All right. So in the last module, we took a look into the Fourth Amendment, kind of exploring those complex rules that govern the searches and seizures by law enforcement. Today, we're going to continue on and we're going to look at the Bill of Rights as it pertains to criminal procedure. And we're going to look at the two most critical amendments that define the rights of the accused, and that is the Fifth and the Sixth Amendments. These amendments protect individuals throughout the criminal justice process from investigation and indictment through trial. So, first up is the actual text of the Fifth Amendment, and it says, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be put twice or twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation." So, for our focus on the rights of the accused in criminal procedure, the core protections that we're going to concentrate on are the requirement for a grand jury indictment for federal felony charges, the double jeopardy clause, which prevents a person from being prosecuted twice for the same offense, the privilege against self incrimination, which is famously known as the right to remain silent, and then due process. And that's ensuring fair legal procedures, though this clause has also a substantive component, which we discussed in the previous week, and a procedural component, though, that broadly applies throughout the justice system. Now, it does have the taking clause also, which is about eminent domain, and it is in the Fifth Amendment, but this is typically covered in a separate kind of property rights, discussion. But as a reminder, almost all of these Fifth Amendment protections have been incorporated, and thus they will apply with equal force to state and local governments via the 14th Amendment's Due Process Clause. So this is why these rights are fundamental across all levels of U.S. criminal justice system. So the first protection is the Fifth Amendment, and the text reads, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury." Okay. And the purpose of the grand jury is to act as kind of like a screening body. Okay. They're like a focus group. So it stands between the government or the prosecutor and the accused. And its role is to protect the citizens from, an unwarranted prosecution or an overzealous prosecution by ensuring that there is sufficient evidence before a formal charge has been brought. So it screens the prosecutor's evidence before the accused is put through the ordeal of going through a public trial. And in terms of function, a grand jury hears evidence that's presented by the prosecutor, which can include witness testimony and documents. And in this case, the accused typically does not have the right to present evidence or even be present during the grand jury proceedings. Okay. So if the grand jury determines that there is enough probable cause to believe that there has been a crime that has been committed and that the accused is actually the one who committed it, then it will issue an indictment, which is a formal charge. And if they do not find probable cause, then they'll issue a no true bill, and then no charges are filed. Now, grand juries typically consist of 16 to 23 people and citizens, I should say, and their proceedings are conducted in secret. The secrecy aspect is intended to protect the innocent from any kind of public accusation. It is to encourage witnesses to testify freely and to prevent flight of those who get indicted. It is crucial to note something, though, about grand juries. And that is, this right is not incorporated against the states. So the federal protections for the capital and otherwise infamous crimes, which were the felonies, must use the grand jury to issue an indictment. But again, the states are not required to use a grand jury, and most of them choose to proceed by using a prosecutor's information, where the prosecutor files the formal charges directly after a preliminary hearing in front of a judge who essentially determines if there is probable cause. And that's a significant difference between the federal and the state criminal justice systems. So, next we have the double jeopardy clause, and the text states, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. I hate the way that's worded. Now, the core principle here is that it keeps the government from prosecuting or punishing an individual multiple times for the same offense after a certain point in the legal process. And the protection is going to apply in situations like where you have an acquittal. And that is once like a jury in a jury trial or a judge in a bench trial finds the defendant not guilty. In these cases, the government cannot try that person again for the same crime. It's an adjudicated matter. When you have a conviction, so once a person has been convicted and punished for a crime, then the government cannot seek to prosecute them again for that same crime. In certain situations with a mistrial, too, a retrial can be barred. I'm going to come back to this, though, in just a second. But the rationale here, again, is about, being deeply rooted in fairness and preventing governmental overreach, right? And it protects against harassment by the government. It's supposed to ensure that there is finality in criminal proceedings, and it prevents the government from using its vast resources to repeatedly just come at somebody and prosecute them again and again until they get a conviction secured. And actually, there's a case, I think it was in Texas, where they kept putting the person through it, and I think it was like on the fifth one, they finally, the Supreme Court said, no, you can't do that anymore. But anyhow, my notes are kind of off on this, so that's why I said we'll circle back. So the mistrial, though. So if a mistrial is declared due to a hung jury, and that means that the jury cannot reach a unanimous verdict, then the double jeopardy clause typically does not prevent a retrial. And that's considered a manifest necessity. And that means that it's for ending the first trial without a verdict. So if a mistrial is declared at the defendant's request, then retrial is also usually allowed, unless the prosecutor has done something to deliberately kind of poke and prod for the mistrial in order to gain some kind of an advantage. Another thing is the separate sovereigns doctrine, and this is a huge exception. So again, the double jeopardy clause prohibits somebody for being tried twice for the same offense, but it's by the same sovereign. So if an act violates the laws of two different sovereigns, then both of them can prosecute. So, for example, if you have a bank robbery, okay, that violates both a state law and a federal law. So the individual can be prosecuted by the state and then separately by the federal government for the same conduct and vice versa. Okay. And again, that's because the state and federal governments are considered separate sovereigns. Now, you also have civil versus criminal proceedings. So the double jeopardy only applies to successive criminal prosecutions. So it doesn't prevent the government from bringing a civil action against an individual that they have acquitted or convicted in a criminal case for the same conduct. Take O.J. Simpson, for example. He was acquitted of the murder in his criminal trial, but he was later found liable for the wrongful death in a civil suit involving the same exact incident. And that is considered permissible under double jeopardy because the civil case was going for monetary damages and not a criminal punishment. Probably the most well-known Fifth Amendment protection is the privilege against self-incrimination, again, famously known as the right to remain silent. And the text states, nor shall be compelled in any criminal case to be a witness against himself. And the core principle here is that no person can be forced to testify against themselves in a criminal proceeding. That is essentially against a fundamental protection against governmental coercion. And it's meant to ensure that the government does its job to gather evidence independently rather than relying on a forced confession. Now, we can debate this one all day long because we know that it still happens. but that's another story for another day. Um, the scope of this privilege is specific, okay? It only applies to statements that are like testimonial. That means that the privilege is going to protect communicative statements, such as like an oral or written assertion of fact. It's not going to apply to physical evidence and protect that, like a blood, test, providing a handwriting sample, or like standing in a lineup. The state can compel those physical acts. Um, the compelled aspect to it, this privilege is going to apply to statements that are made involuntarily, and it's usually through some form of government compulsion, like police interrogation or subpoena to testify. So it's not going to apply to voluntarily made statements. You also have incriminatory statements, and this kind of statement, it has to be potentially incriminatory, meaning that it could reasonably lead to a criminal prosecution and could be used as evidence against the person in a criminal case. Okay. So again, let's talk about when it can be claimed. This particular privilege is not limited to just criminal trials. It can be claimed in any proceeding, whether it's criminal or civil or administrative or even a legislative hearing, where a person's testimony might be compelled and could potentially be used against them in a criminal prosecution. Okay. So, for example, if you have a witness in a civil lawsuit, they could invoke their Fifth Amendment if their testimony might somehow expose them to criminal charges. Now, let's talk about invoking the privilege, because this privilege is generally not automatic. A person has to actively assert that privilege, okay? So they must claim their Fifth Amendment right to remain silent in response to a specific question rather than just remaining silent to ensure it's protected, okay? Sometimes the government wants a person's testimony so badly that it will grant immunity in exchange for that testimony. And in these kinds of cases, there are two types of immunity. You have transactional immunity, which is a more broad form. This is going to grant full immunity from prosecution for the offense to which the compelled testimony is going to relate. So essentially, if you testify about a crime, you can't be prosecuted for that crime. And this is rare. Then you also have use and derivative use immunity, and this is more common. And it means that the compelled testimony itself cannot be used against the witness in a subsequent criminal prosecution, nor can any evidence that is derived from that testimony, okay? Now, the witness can still be prosecuted for the crime if the prosecution can prove guilt using independent evidence that was not, derived from that compelled testimony. This protects that Fifth Amendment right because, again, the testimony itself cannot be used as a witness against himself, which is literally in the statement or in the text itself. Now, the most famous application of privilege against self-incrimination outside the courtroom is in police interrogations, and this was established in the landmark case of Miranda versus Arizona. So Ernesto Miranda was arrested in Arizona, and he was accused of kidnapping and rape. And he was interrogated by police for 2 hours without being informed of his right to an attorney or his right to remain silent. And he ultimately signed a written confession. Now, at the trial, the confession was admitted as evidence, and he was convicted. Miranda appealed that, arguing that his confession was obtained in violation of his Fifth Amendment right against self-incrimination. So the issue before the court was, does the Fifth Amendment's right against self-incrimination require that an individual be informed of their rights to silence and to an attorney before they can be interrogated by police while in custody? And if not, is their, confession admissible? And the Supreme Court held that it does require that person to be informed of their constitutional rights before they are subjected to what would be considered custodial interrogation. And any statements that are obtained without those warnings are generally inadmissible in court. Okay. Now, Chief Justice Earl Warren wrote the opinion for the majority. And he said that the court recognized, the inherently coercive nature of custodial interrogation. That means questioning by a police when a person is deprived of their freedom of action, meaning they can't just leave. Okay. So to protect the Fifth Amendment right against self-incrimination in this coercive environment, the court mandated specific warnings that are now known as the Miranda warnings. And the police has to give a suspect these warnings before a custodial interrogation. The warnings include the right to remain silent, that anything said can and will be used against them in a court of law. They have the right to an attorney, and if the individual cannot afford one will be appointed for them. And the court stated that these warnings, if they're not given, then any statements that are obtained during custodial interrogation are presumptively compelled, and therefore they're inadmissible in the prosecution's case in chief. And you have the ability to get a suspect to waive those rights. But again, if they are going to waive those rights, it has to be done voluntarily. It has to be also knowing exactly what it is that they're doing. Now, the impact of Miranda was huge. And by the way, it was made up of more than just Miranda's case, but it got consolidated down to just Miranda. But it fundamentally reshaped police interrogation practices across the U.S., and it immediately led to the adoption of the Miranda warnings by law enforcement agencies nationwide, which have become iconic in popular culture. And it ensured that suspects in custody, they're aware of their constitutional rights before being subjected to what could potentially be coercive interrogation. Now, while it was initially controversial, Miranda has become kind of a foundational principle of criminal procedure, ensuring at least there is a minimum level of procedural protection for those who are facing police questioning. Okay. It is important, though, for me to add here that there is an exception to Miranda, and that is the public safety exception. So if the police ask questions reasonably prompted by concern for public safety, like, where's the gun? Then the responses to those questions are going to be admissible, even if Miranda was not given. That exception balances, or it's intended to balance, the Fifth Amendment against immediate threats to public safety. Now, it is also worth mentioning that while Miranda regulates custodial interrogation, there are extensive rules and case law that governs the interrogation techniques in general. And the Due Process Clause broadly prohibits confessions that are obtained through actual coercion or involuntariness, regardless of Miranda. So factors like the duration of the interrogation, the intensity of the questioning, are they being deprived of, food or sleep? Are they getting threats? Or even are they getting promises that can, all render a confession involuntarily, and they're inadmissible even if Miranda warnings were given. So now let's transition to the Sixth Amendment, and it focuses on the rights that are afforded to individuals in all criminal prosecutions. And the Sixth Amendment gives us a comprehensive set of protections that are supposed to guarantee a fair trial. Now it says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So to kind of sum it up, the core protections here are the right to a speedy and public trial, the right to an impartial jury, the right to be informed of the nature and cause of the accusation, the right to confront your witnesses, meaning you have the right to cross-examine them, The right to compulsory process for obtaining favorable witnesses, meaning you can subpoena them to compel them to testify. And most famously is the assistance of counsel. Now, um, unlike the grand jury clause of the Fifth Amendment, all of these Sixth Amendment rights have been incorporated and equally applied, with the same force to state and local governments through the 14th Amendment's due process clause. Again, to ensure that there is consistent standards of fairness in criminal prosecutions across the country. And again, I know we can argue these things back and forth all day long. So don't shoot the messenger. So let's break down the Sixth Amendment's specific protections, starting with that right to the speedy and public trial. Now, the right to a speedy trial prevents the government from holding a person indefinitely or delaying their trial unnecessarily, which could lead to undue prejudice against the defendant. For example, you have witnesses' memories, they fade. Evidence gets lost. You might have a defendant who suffers from anxiety. Well, the Supreme Court has adopted a balancing test to determine if a speedy trial right has been violated, and they look at four different factors. The first is the length of the delay. How long has passed, between the accusation to the trial? Then they look at the reason for the delay. Like, was it due to a justifiable reason, meaning like maybe you have an unavailable witness, or is it prosecutorial neglect or bad faith? Then you have the defendant's assertion of the right. And that is, did the defendant actually demand a speedy trial? And then you have the prejudice to the defendant. Has the delay actually harmed the defendant's ability to present a defense or cause them some sort of undue suffering? So if the court finds that the speedy trial violation has happened, then the remedy here is, often really dismissing the charges against the defendant. So the right to a public trial means that criminal proceedings, generally including the trial itself, the jury selection, and other important hearings, they have to be open to the public. And that is intended to ensure that there is transparency and fairness, to guard against, arbitrary or secret proceedings that could somehow lead to abuses of power. And it promotes public confidence in the justice system by allowing citizens to observe how justice is administered. So, while the right to a public trial is strong, there are exceptions that are allowed in limited circumstances, such as like the right to protect the privacy of minors, or sensitive victims, or trade secrets, or even just to maintain order in the courtroom. But any closure of a courtroom has to be strictly necessary and narrowly tailored. So another fundamental Sixth Amendment protection is the right to the impartial jury. And the purpose of a jury trial is not just to gather facts, but it's also to guard against government oppression and to ensure that there is fairness by allowing ordinary citizens to participate in the administration of justice. So it kind of takes a mixture between like a group of peers, between the accused and the state to help make the decision. Okay. And the right to an impartial trial or an impartial jury rather, has two main components. So you have the fair cross section of the community, which is the jury pools themselves. This is the pools from where the juries are drawn. They have to represent a fair cross section of the community. That means that no distinct or specific group, like based on race or gender or ethnicity, can be systematically excluded from the jury selection. And that is to ensure that the jury reflects diverse perspectives and that the defendant is not judged by a jury drawn from a biased pool. Now, it is important to note here that this does not require the petite jury, which is the actual trial jury of 6 or 12, to be perfectly representative of the community. It only requires the pool from which they are drawn to be representative of it. Now, the second thing is the impartiality. And the individual jurors themselves, they're chosen for the trial, and they have to be unbiased and able to decide the case solely on the evidence that's presented in court. Now, this is primarily achieved through the voir dire process or the jury selection process. And during voir dire, the lawyers and sometimes the judge can question the prospective jurors to uncover any kind of biases. You might have a challenge for cause that comes up where, lawyers can ask the judge to remove a prospective juror for cause if they demonstrate a clear bias or an inability to be impartial, like they know the defendant, or they state that they would never convict based on circumstantial evidence, things like that. Those kinds of challenges are unlimited. But then you also have the peremptory challenges, and lawyers have a limited number of peremptory challenges. And this will allow them to remove a prospective juror without stating a reason. Okay. Now, the Supreme Court has ruled that the peremptory challenges cannot be used in a discriminatory manner, like to exclude jurors based on race or gender, because that would violate the Equal Protection Clause. Now, you, okay, let's talk about the jury size and a unanimous decision. So in a federal criminal trial, the Sixth Amendment requires a jury of 12 members and a unanimous verdict for a conviction. For state criminal trials, the Supreme Court has held that a jury can have fewer than 12 members, but there has to be a minimum of 6 jurors permissible. I mean, a minimum of 6 jurors is allowed for a felony case. If the state uses a 6-person jury for a felony case, then the verdict has to be unanimous. For 12-person juries in a state felony case, for a long time, the court allowed a non-unanimous verdict. But in 2020, we had the case of Ramos versus Louisiana, in which the Supreme Court ruled that the Sixth Amendment right to a jury trial, as incorporated against the states, requires a unanimous verdict for conviction in all state felony cases, which overturn the prior precedent. Now, we also have the right of confrontation, and this is a crucial right for, to ensure fairness. And the text states to be confronted with witnesses against him. And the purpose of this clause is to allow the accused to confront and cross-examine witnesses who offer testimony against them. And it serves multiple goals. It is to ensure the reliability of the testimony by subjecting it to, kind of the rigors of cross-examination. It allows the jury to assess witness credibility by observing their demeanor, and it forces witnesses to face the accused in court. And the core right is the physical presence of the witness in court under oath and subject to cross-examination by the defense. Okay. Now, this right often comes into play when the prosecution tries to introduce hearsay evidence, which is an out-of-court statement that is offered in court to provide the truth of a matter that is asserted. So, while many forms of hearsay are admissible under the rules of evidence, the Confrontation Clause imposes an additional layer of constitutional scrutiny, especially for testimonial hearsay. And the landmark case that clarified this distinction is Crawford v. Washington. So Michael Crawford was charged with assault, and his wife had made out-of-court statements to the police in a recorded interrogation that implicated him in the stabbing. Now, at trial, his wife invoked marital privilege, meaning that she could not be compelled to testify against her husband. So she didn't. All right. Now, the prosecutor then introduced her recorded statements to police as evidence against Crawford. And he argued that admitting his wife's out-of-court statements violated his Sixth Amendment right to confront the witnesses against him because he had absolutely no opportunity to cross-examine her. So the question before the court was, does the Sixth Amendment's Confrontation Clause prohibit the introduction of a non-testifying witness's out-of-court testimonial statement made to police, even if it falls under a hearsay exception, when the defendant had no prior opportunity for cross-examination. And the Supreme Court said that admitting the wife's recorded statements did violate his constitutional right to confrontation. The court established in this case a new testimonial hearsay standard. So Justice Scalia wrote for the majority, and he said the court moved away from a prior test which focused on the reliability of hearsay, and it emphasized a more textual and historical interpretation of the Confrontation Clause. And Justice Scalia ruled that if an out-of-court statement is considered testimonial, then it is inadmissible under the Confrontation Clause unless the declarant, which is the person who made the statement, is unavailable to testify in court and the defendant had a prior opportunity to cross-examine the declarant. If both cases, if both of these conditions, rather, are not met, then the testimonial hearsay is going to be barred. Now, the court defined testimonial statements as those that are made under circumstances that would lead an objective witness reasonably to believe that the statement would have been available for use at trial later. That includes things like statements to the police and interrogation that are aimed at establishing or proving past facts that are relevant to a criminal investigation, like the wife's did. Affidavits is another. You have prior testimony that may have been given, say, at a preliminary hearing. You have statements that are made to government officers to establish facts about a past crime. Okay? Those are all examples of testimonial. In the alternative, you have the non-testimonial hearsay. And this is admissible under the traditional rules of evidence if a hearsay exception applies. And it doesn't fall under the Confrontation Clause. So these are statements that are made not to establish facts for future prosecution, but, for example, to obtain emergency aid. So a classic example would be like a frantic 911 call describing an ongoing emergency, right? That is where the primary purpose is to get help, not to provide evidence for a future trial. All right. So the impact here is that Crawford v. Washington, it dramatically strengthened the Confrontation Clause protections, especially against police elicited statements. And it made it much more hard for prosecutors to use out-of-court statements from absent witnesses, particularly if those statements were obtained in a formal way for investigative purposes. So it forces the prosecution to bring witnesses to court for live testimony and then cross-examination whenever their out-of-court statements are testimonial, thus reinforcing that core purpose of the Confrontation Clause. Now, the Sixth Amendment also provides the accused the right to compulsory process, and it says to have compulsory process for obtaining witnesses in his favor. And the purpose of this clause is to ensure that the accused has the means to present a full and robust defense, okay? It's a fundamental aspect of adversarial justice, and it gives the defendant the ability to counter the prosecution's case. Now, the core right here is the ability to compel the attendance and the testimony of favorable witnesses. That means that if there's a witness who has information that could help the defendant's case, the defendant has the right to compel or subpoena that witness to appear in court and to testify. And that prevents the government from hindering the defense by preventing key witnesses from testifying. Now, beyond just witness attendance, the compulsory process also has been interpreted to include the broader right to offer evidence and testimony in one's own defense. And that means that the defendant can present evidence, call witnesses, and testify themselves, all subject, of course, to the rules of evidence. So now we have probably the most iconic and frequently invoked Sixth Amendment right, and that is the right of assistance of counsel. And the text simply states to have the assistance of counsel for his defense. So the history of this right is so important. Initially, the Sixth Amendment was interpreted to mean that a federal defendant had the right to hire a lawyer if they could afford one. And the government was only required to provide counsel for those that were indigent or poor. And in a federal capital case, which they were seeking the death penalty for. So it was not seen as a right to appointed counsel for all poor defendants, especially in state courts. And that changed significantly in the 20th century. So the landmark case that revolutionized this right, especially for indigent defendants in state courts, was Gideon versus Wainwright. So Clarence Gideon was a poor man who was charged with breaking and entering a pool hall, which was a felony in Florida state court. And he appeared in court without a lawyer and requested that the court appoint counsel for him because he couldn't afford one. And the Florida judge denied his request, stating that under Florida law, counsel could only be appointed for indigent defendants in capital cases. Okay. So Gideon was forced to represent himself, and he was subsequently convicted and sentenced to 5 years in prison. So from prison, he famously filed a handwritten petition for a writ of certiorari with the Supreme Court. So the issue before the court was, does the Sixth Amendment's right to counsel apply to indigent or poor felony defendants in state court proceedings, requiring the states to provide them with attorneys? And the Supreme Court unanimously held that the Sixth Amendment's right to counsel does apply to indigent felony defendants in state courts, requiring them to provide attorneys, because this right is fundamental to a fair trial. So Justice Hugo Black wrote for the majority, which was all of them, but the court reasoned that a person's ability to receive a fair trial should not depend on their ability to pay for a lawyer. And Justice Black famously wrote that in our adversary system of criminal justice, any person hailed into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. This seems to us an obvious truth. So the court considered counsel a necessity, not a luxury, and it emphasized that even intelligent and educated lay people cannot possibly navigate the complexities of criminal law, present a proper defense, cross-examine witnesses, or understand legal procedures without legal assistance. So this assistance of counsel was something that was fundamental to due process and a fair trial. So the impact of Gideon was huge, right? It effectively created this right to state-appointed counsel for all indigent felony defendants in state courts, leading to the establishment of the public defender systems across the country. And it dramatically expanded the right to counsel, ensuring that access to justice is not solely dependent on wealth, okay? And this case is often cited as a cornerstone of modern criminal justice system and really a triumph for, equal justice under the law. So the scope of the right to counsel has been further defined since Gideon, and it applies to all felony cases, state and federal, and it also applies to misdemeanor cases where actual incarceration is imposed. That means if there is any possibility of jail time, then the right to counsel attaches. It applies to all critical stages of the criminal prosecution. That means from the initial appearance, like where the charges are read, bail is set, through pretrial proceedings, the trial itself, sentencing, and the first appeal of right. But it's not just limited to the courtroom trial, okay? Also, the right to counsel is not merely a right to any lawyer, but to effective assistance of counsel. And that critical protection ensures that the lawyer provided or chosen is supposed to actually perform competently. And the standard for evaluating claims of ineffective assistance of counsel were established in the landmark case of Strickland v. Washington. So David Washington was charged with 3 very gruesome murders in Florida, as well as kidnappings, assault, and grand larceny. And he confessed to some of the crimes, and he pled guilty to several charges. So his court-appointed attorney, a fairly inexperienced public defender, decided not to seek out character witnesses or to request a psychiatric evaluation for his client. And that decision was based on the lawyer's belief that presenting such evidence would not help at the sentencing phase, especially given Washington's confessions and his expressed remorse. So at the sentencing, the judge found that there were aggravating circumstances, meaning that it made the crime more severe, and there were no mitigating circumstances, which made it less severe. And he sentenced Washington to death. So Washington later argued that his Sixth Amendment right to effective assistance of counsel had been violated because his lawyer's performance was deficient, particularly in that sentencing phase, and that the deficiency prejudiced his defense. So the question before the court was, what is the proper standard for judging a criminal defendant's contention that the Sixth Amendment right to counsel has been so violated that the conviction or the death sentence should be reversed? And the Supreme Court held that to demonstrate ineffective assistance of counsel, a defendant must satisfy a two-pronged test, okay? And applying this test, the court found that Washington's attorney's performance, while not ideal, did not fall below an objective standard of reasonableness. And even if it had, Washington failed to show that it prejudiced the outcome of his sentencing. Therefore, it upheld his conviction and his death sentence. So Justice Sandra Day O'Connor wrote for the majority and said that the court recognized the inherent difficulty in judging attorney performance, especially after the fact, and the need to give deference to a lawyer's strategic decisions. And she said, they established the now famous two-prong test for ineffective assistance of counsel claims. So defendant has to prove both prongs in order to succeed. The first is deficient performance, or the performance prong. And the defendant has to show that the counsel's performance was deficient. That means that the lawyer's errors were so serious that counsel was not functioning as the counsel guaranteed by the Sixth Amendment. And that standard is one of reasonableness under the prevailing professional norms. So it's an objective standard, meaning that the court is going to ask whether a reasonably competent attorney would have acted differently. And this prong aims to ensure that lawyers provide a minimum level of professional competence. It's not about second guessing like every tactical decision, but just identifying errors that were so significant that they fall outside of the wide range of professionally competent assistants. Okay. Now, in Washington's case, the court found that his attorney's decision to not seek certain evidence was a reasonable strategic choice in the context of his client's confession and remorse. Now, the second prong is the prejudice prong, and so they're looking for prejudice. So the defendant has to show that this deficient performance is what prejudiced the defense, okay? And that means that there is a reasonable probability that but for the counsel's unprofessional errors, the result of the proceeding would have been different. So a reasonable probability is defined as a probability that is sufficient to undermine confidence in the outcome. It's not enough that the error merely had some conceivable effect, okay? That the defendant had to demonstrate a substantial likelihood of a different result. And so this prong focuses on the impact of the lawyer's errors on the trial's fairness and the reliability. So in Washington's case, even assuming that his lawyer was deficient, the court found that given the overwhelming aggravating evidence and the minor nature of any kind of potential mitigating factors, there was no reasonable probability that the outcome of his sentencing, which was the death penalty, would have been different had his lawyer performed differently. So Strickland v. Washington, it's still the controlling precedent for all claims when it comes to ineffective assistance of counsel, both at the federal and the state level. And this two-part test, it's incredibly difficult for defendants to meet. That deficiency prong is what gives wide deference to attorney strategy. And the prejudice prong requires a showing of a direct and significant impact on the outcome. And so it creates this high bar, and it reflects the court's desire to preserve the finality of convictions and to avoid like endless appeals based on, minor attorney mishaps. or I guess I should say missteps, but mishaps works too. So while Gideon promised the right to counsel, Strickland defined what the counsel must actually do, which was setting a demanding standard for proving its ineffectiveness. And that's pretty much for this one. Just remember that these rights, they're not isolated. They are part of an interlocking system that is supposed to be designed to safeguard that fairness throughout the criminal justice process, from the initial investigation to the trial, to the appeal. And they reflect this core constitutional commitment to due process and the presumption of innocence. Now, ultimately, these amendments seek to strike a delicate balance, protecting, the power of the state, which is vast, to investigate and prosecute crimes against the fundamental rights of the individuals who are accused. Again, hoping to ensure that justice is administered fairly and impartially. Okay. And this balance is constantly tested and refined by new cases and societal challenges, but the principles laid out in these amendments are still foundational. And that's pretty much all I have to say. Let me know if you have any questions. Bye.